that way, foundation and the record. So all good. I'm happy to start with and kind of go through some as well.
So I have the actual stipulation, Judge, and I did email it to it didn't come through because then I was going to electronically file a copy here. Take it and scan
Absolutely.
it. Okay.
We still take paper
I
in the courtroom.
apologize. I did just thought I emailed it.
Okay. All right, I was just taking a moment to read through that stipulation. Looks like Attorney Opera, you hand signed that, obtained the electronic signature of purposes. Attorney Keys, I'm going to have you initial or at least sign it so that we have the original on file then with the court. Parties will, once we get it e-filed, of course, you can maintain that copy for your records. And on the record, it says, please take notice that the state of Wisconsin by Susan L. Opper, District Attorney, and the defendant, Darrell, consent of his attorneys, Jeremy C. Perry and Anna M. Keys, stipulate to the following, that all parade true and accurate depictions of the events of November 21, 2021, and that foundation testimony. It's dated and signed by Attorney Opper and Attorney Keys the 15th day of in the city of Waukesha, Wisconsin. So I, Attorney Keys, since you signed this on behalf of your client, I presume that you had a conversation with him regarding this stipulation and the effect at trial. All right, any record you would want to make regarding that before I question him briefly on it?
We last week, I believe, I can't remember the day off the top of my head, but we discussed what it means, foundation of the video, meaning that the video is on that particular day, and that we don't need somebody to say that's the video that I took on that particular day. And
since I obviously haven't seen any of these videos, but I can only imagine, and maybe I'll turn to the state for this portion of it, that there are a number of videos during the course of this trial.
Correct.
Do you have a number of witnesses that this stipulation would impact, meaning they wouldn't need to come in?
I would estimate about 50 to 75 witnesses.
Would have been to lay the foundation for the videos?
Yes.
Is that your understanding, Attorney Keys? All right. Speed things up as we go through. Mr. Brooks, I would see this issue as one that your attorneys, as the attorneys assigned to you in this case, right to make a decision. It's really a trial strategy decision, but I want to make sure that you understand it. Certainly to get your agreement, that's what the stipulation says. So did you have an opportunity to discuss with your attorneys this, the videos?
Yeah.
Do you understand that by your attorneys entering into this, it will mean that approximately 50 to 75 witnesses will not be called to lay those witnesses?
Yeah.
Are you in agreement with your attorney's stipulation in this case?
Yes, ma'am.
You understand the advantages and disadvantages of the stipulation? Do you have any questions that you need answered by your attorneys before the court accepts this? Anyone make any threats or force you in any way to, even though you haven't signed it, you're telling me you agree to it, so to.
Let me say it again.
Sure, even though you didn't sign this stipulation, I'm told verbiage of it that you agree with it, and I want to know if anyone made any threats to accept the stipulation.
No, ma'am.
Anyone make any promises to you other than the stipulation itself, meaning these witnesses won't be called and the videos will be authenticated in exchange for you agreeing to it?
No, nobody promised me that.
All right, thank you. Then I've reviewed the stipulation. The court will accept the stipulation. The stipulation, of course, relates to the foundation testimony of witnesses who took video related to the parade. And the state, through this stipulation, of course, and by advising the court accordingly, will not need to call the various witnesses on foundation questions. There could be other testimony that I suppose a witness is asked, but as to the foundation of the videos, then the state will be able to proceed with that part being satisfied.
And just to point out, Your Honor, the defense expert also relied on many of the same videos, so it's a two-way street.
Oh, thank you. I appreciate that added statement. Attorney Keyes, you would agree with that as well?
Yes.
All right, great. And you understand that as well, Mr. Brooks? That your expert, that you're going to case also relied upon to render his opinion.
Yeah.
All right, thank you. Okay, then we'll, Madam Clerk, you can now scan that in and file stamp it. Before I get to the motions in limine, I want to type matters. One is I am looking for, or from the parties, a pool number that you will be asking to do individual voir dire. Their jury questionnaire that you believe warrants the individual voir dire. My questionnaire, or not my questionnaire, but my script. What I'm really looking for is obviously decisions. I told the parties that if appropriate, individual jurors would be subject to individual voir dire questions in their jury questionnaire, or their answers in their jury questionnaire, primarily related to media exposure. The idea behind that being many of the questionnaire have very limited exposure to media, some more than others, some not at all. We don't necessarily need a juror saying what they've heard about Mr. Brooks from other cases, for example, right? And so that might be a question that the parties would seek to have a juror question about. Some of the follow-up that I would do with these jurors is simply, from the parties, what questions you specifically want me to question. And if you recall, going back to the hearing we had on the jury questionnaires, I denied some of the requests to strike jurors for cause because I said, frankly, there needs to be follow-up regarding that individual juror. So it might be appropriate to have that juror, even in open court, they'll have their jury questionnaires. They've answered question number 26. My follow what the answer is, but then to follow up with, is there anything about your exposure to media that you have regarding Mr. Brooks? that would in any way interfere with your ability to be a fair and impartial juror in this case? Have you formed an opinion about this case based upon the information that you've seen or heard? So those are some general ways to address those topics, which I think will be a way to either uncovering any bias or prejudice or dispelling any that the answers to the questions may have raised. But I also promised the parties they'd have an opportunity to ask questions both while we're in court together with all the jurors and individual voir dire, right? I mean one-on-one with outside the presence of the other jurors. But I want to know what those requests are, because one, that may alter how I question them during jury selection, but also just to really form kind of a game plan on when would be the appropriate, because what will need to happen is, and if I haven't made this clear, you'll see we'll be doing jury selection in this courtroom. The courtroom next door to us, which is normally occupied by one of my colleagues, will be available to us. If there is the need to do individual questioning, who aren't being questioned are going to go into that courtroom. They'll be monitored by court staff, and then we'll proceed in the courtroom with that individual jury selection. Now, the same will be a different format because jury selection will also involve some remote observation. You all are in this courtroom. You can see I have 4 benches per on each side of the courtroom. I can in this courtroom. I can fit a large amount of jurors, probably what I was thinking, about 40 jurors, so that kind of gives me a little bit of a cushion if there are. We know we need 36 strikes each and then down to 16, so I thought if I had 5 extra or so. And then the remainder of the jurors will be in room 215. That is where what will be our jury assembly room for this trial. And so through I'll be live streaming, but what they will, actually I won't be live streaming, is I'll be able to connect them through the room systems. And if there gets to be a point in time where we need that off, but the entire 105 jurors who are called in the first day will be one of us, or while they're in 215, again, there will be ample staff there from the clerk's office. We'll be able to see some of them, and we have on our list of things to do some test, audiovisual tests with the system since we're in the new tower, and that's in the house. We're probably not going to see all of them, but they'll have a folder that the clerk's office prepares. It will have their jury questionnaire. It will have the additional questions that we approve here today that they fill out. Will need to be made and handed out to the parties. And then a pad of paper, a pen. All the questions will be by number so that they can follow along, and if they'll be instructed. If question 1, you would write that down, write some notes to yourself. So ultimately, if any of those jurors from 215 are brought down here because we've had a number, then I can very easily go through those questions with them and ask, you've heard questions 1 through, let's say I've gone through 25 at that point. Any of those questions would you have answered, what would your answers have been? So that's how the jury selection process of it will go, with about 40 here, the remainder in 215, functioning as the jury assembly room, but with that connection to us by means of the items in each. So, getting back to what was on my housekeeping, have any questions about that? Everyone understand kind of conceptually what I have envisioned for jury selection from the state?
Yes.
I want to clarify that the ultimate list we provide, only those items that we think need to be done outside of the presence of the rest of the jury we intend to follow up with a particular potential juror.
I'd say certainly the first part of that, any juror that you believe should be subject to individual voir dire and what question, or end on what question. And then if there's any follow-up you want the court to do, as opposed to that follow-up at the appropriate time, since both sides are going to be able to do follow-up as well.
You know, from things that we objected to, that we brought up, that we think are comfortable doing it in the presence of, wouldn't taint the rest of the jury pool, and we would like to do that ourselves. We don't need to have that all spelled out.
Only if you want the court to do it on your behalf. Since I'm doing the bulk of it, right, it's sometimes, yeah. Is that, any questions on that from the state?
No.
Okay. So I was thinking, let me look at a calendar. Like I thought I wrote it in the email, by 9/26. So that list, is that, I think that's doable for everyone.
I'm sorry, Judge.
Just notified me of the jurors, and you can focus on, well, up to you on whether it's all of or focusing on the first 105 who will be called the first day.
Okay.
My end up needing to go above and beyond the 105. You might have a little homework on that Monday night to work and submit something to me by the morning, but that should limit your work a little bit.
Okay.
I tried to describe it as best I could in the email about how the jurors are randomized. And I can just explain it on the record if in any event. So we're not able to re-randomize the jurors until they check in. My intent, again, is to call 100. We would go to the remaining number on the fourth day. It's possible that have a family emergency or something, and so we don't want to re-randomize them until everyone's checked in that first day. So that 105 initially will be reshuffled, shall we say. In most trials, you get that list where, 1 through 26, maybe on a simpler case. 105, and I can't pull out from the 340 now. I can't randomize them yet, but I can do that when they come in, starting with 105. And then if we have to keep going, I'm told the computer application program will keep adding, adjusting the first. It kind of helps you in preparing. You can at least start with the first 105 for Any questions on that? I know it's not the most clear because it's a little bit different what we had to do in this case, but hopefully that makes sense.
Thank you.
From the defense?
No questions on that.
Okay. Of jury selection, I know the parties, this is number 6 on my email, have submitted some follow-up questions for the court to supplemental written questionnaire to give to the jurors as they enter in and check in for jury selection, fill out, provided to the parties prior to the jurors being brought in to court and sworn in. So I have a list that the filed, which are 8 questions. And then there's 2 questions. Dear, or were those for the supplement? Something as the state had review the questions submitted by the defense
I have,
on those.
yes.
Okay, go ahead.
On question 1, which the question is, since you first completed the jury questionnaire in this case, what is that's so general, I guess was a little bit more, I think it's trying to elicit the same types of responses. What additional information have you learned about Darrell Brooks? I think the best way to go is to, here's your questionnaire, please review the answers. Now, some of those questions, as I have the jury questionnaire before me, is, you know, what information about Mr. Brooks and his prior cases? Did you see any media coverage of the parade incident? I really wanted them to reference that questionnaire.
Your supplement
Correct.
tries to do. It's really broad, says review it, look at it. Would you, any of your, today?
Correct, because I think then that encompasses, like, question number 2, have you attended any recent fundraisers associated with the parade? And again, that was a question that was asked in the original questionnaire, and that would be encompassed. Same thing with number 6. Would you describe the parade as a transformative event, either for yourself or surrounding community? As it relates to themselves, that would be in the questionnaire. The surrounding community, the relevance of that to a particular juror.
Let me hear all of your objections.
Again, I think number 3, have you case against Darrell Brooks? I think that's also encompassed in number 1. Have you spoken with anyone with direct knowledge of the November 21st parade?
Let me hear all of your objections and I'll have the defense respond.
Again, I think number 3, have you read any recent media coverage of the case against Darrell Brooks? I think that's also encompassed in number 1. Have you spoken with anyone with direct knowledge of the November 21st parade? I'm assuming that the courts, and I reviewed the sample questions. I think that's probably something the court's going to be including in the general voir dire initially, I would think. Number 5, the court denied the other acts motion, so I think that is irrelevant. Again, number 6, I already talked about. I think that's encompassed in my question number 1. Number 7, if you know someone who is directly affected by or is closely connected, again, that was addressed by the jury questionnaire. And then number 8, at this moment in time, is Darrell Brooks guilty or not guilty? frankly, I thought it should be, and I think this is a question that oftentimes is asked by the court, as Mr. Brooks sits here today, he is innocent. Does anyone disagree with the state of the law with regarding that? I mean, I think that's just always been a question that a court has answered or is asked. So again, I thought the question in of itself, I don't think was properly worded from how I view it. I think they need to be shown, this is the law. He's innocent as he sits here today. Is there anyone that disagrees with that?
Great, thank you. For the defense, the response?
Well, we'd agree that number 5 of our proposed questions could be stricken, but I don't think that it has to be one or the other. They're going to be provided with the questionnaires. They're going to be asked to update it. But we are hoping to draw attention to certain things and cast a wide net. And it's one thing, I think, just from, we've all experienced being handed something that's, in this instance, it's, in excess of 100 questions, I think. And being asked to say, do you need to update anything in here in terms of the careful reading through versus the attention being drawn to a number of items and being asked about those number of items. So I think they should do both, frankly. I think they should be given their questionnaires, asked to update it if there are any. But the goal here, right, should be doing everything possible to ensure that we're not missing things that would result in a biased juror sitting on this case. And so if it's, it doesn't sound like, with the exception of the wording of that final question, it doesn't sound like there's an objection to finding out this information. It's just that there's an objection to them being asked to update the questionnaire and then being asked the specific info. And so our request is that they be asked to do both so that we can cast a wide net, I guess, is the goal. And trying to phrase these things in ways that will result in a meaningful update, as opposed to review this lengthy questionnaire and say whether or not any of your answers would be different now, as opposed to, since you submitted this, what else have you learned, and so on. I think that eventually with instructions, and this is going to be part of it all in terms of an instruction on the presumption of innocence, but it is important, and it's a different question. It's one, the question that we worded, that we suggested, is to find out how people view Mr. Brooks right now. And it's a different question. It's also important to ask is, the law is X. Do you agree with that, and can you follow that instruction? But it's important to get answers to both in terms of the bias that some people have when they walk into this courtroom, and then if that answer is yes, that needs to be explored with further questions, as opposed to an answer of I'll follow the court's instruction, or I will agree to follow the law in this case. So we're fine with number 5 being stricken, since the other acts are not coming in, but we'd ask that the remainder of the questions be asked. I don't have any objection to the state's proposed follow-up questions.
Yeah, if I could have a brief.
Go ahead.
I'm sorry, are you done, Travis? If you had any more, go.
Go ahead.
Okay. I guess the only thing I would say is, I think all sides, including the court, worked very hard on this questionnaire to make sure that any concerns that either side had were addressed. And I think then to start picking out certain questions, and they were saying that the other ones, don't bother looking at those because these are the ones that we're focused on. They're all important questions in their own right. And I think that's why it's very important to tell the jury how important this duty is. The other thing that came to my attention, I know it wasn't on the defense list of questions, but hopefully they would agree, after having reviewed hundreds of still shots and screenshots and videos that were taken, is I think the jury needs to be prepared for that. And one question I didn't have would be something to this effect, which are graphic photographs and videos will be shown during the course of this trial that can be described as shocking and highly disturbing and may cause trauma. Knowing this, and again, the verbiage on this, I'm not saying is exactly right, but can you be a fair and impartial juror? Can you sit on this case and be a fair and impartial juror? Again, these videos that we've gone through as we've met with the victims are very graphic. They're very shocking. And I think that we probably want to prepare the jury for what they're going to see.
I think I have a similar question in one of the scripts that I provided to the parties.
It was in a sexual assault.
Might have been in both then. You know, in question 41 of the Benton script, it says, in this case, you are likely to hear and see graphic testimony. Is there anyone here who, because of squeamishness or unease, believes that they would not be able to sit through such testimony and evidence? It's not quite the same as what you said, and I realize certainly not at the same magnitude, although having sat through that trial, there was some very disturbing video and testimony certainly about it.
Could be along those lines. I mean, like I said, they will be shown the video, they will be shown pictures. I don't think they could be categorized as anything other than shocking to the conscience.
If you're able to type that up and maybe email that to,
Absolutely.
on that email chain that we have, I think it's appropriate to ask something like that. I actually thought of a question before I rule on what you all have proffered that was not in the jury questionnaire, and I'm not sure if it's because of the timing of it, was to ask anyone whether they have made a claim in any capacity related to the parade, because that would identify financial interest. And so I'd like to put that in the, either ask it during my script. And again, we're talking about, there's going to be a lot of questions asked that are in open court. My purpose in asking the parties to supplement would be, frankly, along the lines of what the state has offered, and that's really to have an update to what's there, review it. Has anything changed? Has any of your answers changed since the time you filled it out until now? Because I think I would agree with what you said, Attorney Basie. We spent a lot of time crafting this questionnaire in an effort to uncover any potential for bias. And that's really what the jury selection process is all about. And I think we need to keep in mind. We all know what statutory bias is. Those are the relationships, people who are related by blood or marriage to a party, related by blood or marriage to an attorney appearing in the case, anyone who has a financial interest in the case. That's why, despite what the people have asked in or answered in the jury questionnaires, we go ahead and ask those questions in any event, in every case, to make sure we hit on statutory bias. What is subjective bias, though? Because that's really what the jury selection process, in addition to if there is any statutory bias, any relationship or financial interest that we seek to uncover, is whether a prospective juror has an opinion or feeling about the case that the juror is unwilling to set aside. Subjective bias refers to a juror's actual state of mind and is usually revealed by a prospective juror during voir dire. And this is quoting from State versus Oswald and a case of State versus Foucher. That is why the court even on one of the scripts that was sent, and maybe even both of them, has this one question that I am guided by Special Material 20 to ask, and that is, are you able to put your feelings or opinions aside and decide this case based solely on the evidence presented and the law as the court defines it for you? We also know from all of the cases that were reviewed, at least by the court, related to the motion to change venue, is that jurors come in with a presumption that they are not biased, right? They don't have a presumed bias. Even in certain relationships, right? We ask more probing questions. And so I think these questions for this supplement need to be geared toward what's already been asked as a general, meaning like what the state has in their proposed question 1, a very general question. Please review your responses to the questions in the jury questionnaire. As you sit here today, would any of your responses be different than those you originally provided? And if so, please detail the question number and your response today. That covers every single question that is on there. I am not looking, other than that, to ask them or highlight specific questions from that questionnaire again. Frankly, the parties can do that through the adversarial process and ask any follow-up that is geared toward and directed toward uncovering subjective bias. And so looking at question 2, question 3, those are really already covered in the questionnaire, so they'll have an opportunity to update that just with the one question that I've already identified that I will include. Question 4, well, not a bad question. I know that in my script, I will ask the parties, I will cover similar topics and I will do appropriate follow-up, and the parties are going to have the opportunity to do appropriate follow-up. So I don't believe we need to ask that in this supplemental that's going to be given to the jurors as they are brought in on October 3rd. So I'm not going to include question 4. Question 5, there's already been agreement, is not needed. Question 6, there's already a question in the jury questionnaire about that. It's not going to be re-asked. Same thing with number 7. As far as question number 8, I mean, I go through a number of questions in my standard script about the presumption of innocence. But I also think it's an important topic, and I won't take any issue with including something in there on the supplemental that touches on this topic. I like the idea, though, of saying something to the effect of, as Mr. Brooks sits here today, has anyone formed an opinion as to whether he is guilty or not guilty? Because that's really what we're getting at. Anyone have any objection to that verbiage from the state,
So that's what I would recommend, actually.
from the defense?
That's fine.
All right, so I'll include that. And then, of course, I'll include the one I've already identified that goes to financial interest, since that was not a question in the questionnaire. And I think that's important, given that there was a process by which people involved in the parade as a victim could make a claim. And I think that's important to know if any of our potential jurors were any of those people. I know the state also had a number 2 on their list. I already include a question like that on my script, so I'm not inclined to put that in there.
As long as it's included, that's all I care.
Okay, that's usually one of the very last questions that I have, or one very close to that. All right.
Judge, I do have one additional follow-up on this.
Go ahead.
You addressed uncovering statutory and subjective bias. I think that as it relates to a lot of the topics that we discussed before, when we were going through the jury pool, that objective bias is going to be something that we will be trying to make a record of in terms of our belief in potential motions for strikes for cause. I do want to put, I want to alert the state and the court. It was my notes at that hearing when we did this that the state referred everyone to the case State v. Lindell in terms of defining the different types of bias, and provided the Court of Appeals citation of 238 with second 422, and the facts in that case involved a prospective juror that had just a lot of connections to the decedent in that case, and how the court had concluded that even under that circumstance, even under those circumstances with the person's answers, that they were not objectively biased. I guess I can see how this was missed because Westlaw doesn't flag this as yellow or red, but that case actually was reviewed by the Wisconsin Supreme Court, and the Wisconsin Supreme Court said that the facts of that case demonstrated that that juror was objectively biased and should have been struck. And so I'll just provide, this will matter more when we're in jury selection, but the Supreme Court citation is 245 with second 689. That's authored by Justice Prosser.
Can I have the last part of that? You said 245 with second.
689.
Thank you.
That's from 2001. And then applying the standards above, we conclude that prospective juror was objectively biased and should have been struck for cause. And so that was, they affirmed on harmless error because I think a peremptory strike had been used. And maybe that's why it's not flagged in Westlaw, but that is the ultimate holding in that case.
I think there's good language in State versus Oswald on similar issues when they talk about objective bias may involve a direct, critical, personal connection between the individual juror and crucial evidence or a dispositive issue in the case, or an intractable negative attitude toward the justice system in general. I think you can also include in that what you were just saying, if there's a direct connection, personal connection, if it's with parties, or in that case, the decedent. Certainly we'll keep all of those things in mind during jury selection. All right, thank you. Anything else then on the questions? Otherwise, I'll move on.
And not from us.
Okay. All right, a couple easy things. Exhibit lists. I would like the parties to prepare as best as they can exhibit lists in advance of trial. I can only imagine there's going to be quite a bit of evidence that will be offered. I would like the state to start at number 1 and use numbers, and the defense with letters. I think that just keeps it simplest. And I'm happy if you just provide that leading up to trial, even the morning of, to Teresa. It's just so that we can keep track of everything as it comes in and somewhat anticipate if we have those lists provided ahead of time. Any objection from the parties from the state?
Just to clarify, that's not a ban on using other items that we didn't anticipate needing?
It's not a ban,
Okay,
just
just our best guess,
right, and
educated guess.
I presume you're gonna pre-mark based upon your list, and if you end up adding something later on, it'll just be at the end of your numbering.
Okay, thank you.
And if you don't use something, that's typical, it happens.
That's
you know.
what I'm afraid of, honestly. We'll mark way more than we need to, but I understand the concern you're trying to prevent, so.
I'm open to discussion if you think there's a better way. I just really want to know, have a general idea of what you anticipate being offered so that Teresa and I can keep track of that.
Okay.
Right. Any objection from the defense?
No, we will do that as best as we can.
Sounds good, thank you. See, I said that was an easy one. Everyone had an opportunity to review the revised order governing trial administration. You'll see in that it does address some seating. Will be some reservation of rows throughout the trial, but yet some caveats to all of that. It does indicate to the media, I will not be live streaming the jury selection process. I think that's for obvious reasons. It is in no way limiting their attendance. It just is providing, for example, that any audio visual recording actually be done of visual only, that it not capture the questions and answers. If it's not obvious, the jury selection may take more than a day. And while I respect the media's right to be present and to report on these events, what I'm trying to do is limit any exposure to potential jurors. What you should be aware of, though, is I am telling them in advance not to watch the proceedings. I had been working with Lauren in the clerk's office on a packet of information really that is going out to these jurors about things like where to park, what door to enter. But I'm also including a modified preliminary instruction 50, telling them to avoid to not watch any of the proceedings coverage, read any articles, do not, so that they're limited. I need to get the revised letter from Lauren, and I'll email that to the parties. You can look at that, and if there are any issues, we can do that offline, but
When did you think you're gonna send that out, Judge?
it needs to go out, so I meant to give that to you all, and frankly, I gave her the revisions and then forgot to have her email it back to me.
Okay.
So I'll have Teresa message her now, and if she can email it to all of us, so you can see that maybe even while we're sitting here this morning or this afternoon. But again, at least this order touches upon some of that. That's obviously not necessary. I mean, it's your concern, but the media may have a concern about that. But I try to balance everyone's right to be present. It's a very limited restriction, if you will, on just during the jury selection process, that they can't capture any audio. I'm allowing for them that I don't even want them recording, other than I think I put in there 30 minutes of B-roll, so they have appropriate coverage. Doesn't limit, they can take photographs, video of me, of all of you. They're not to, of course, capture any images of jurors. There's already in the order a prohibition on photographing and capturing victims. We'll need to get to your specific request in due course, but this is the general order. But anyone have any issues with that from the state?
Not on that topic. I did want to have some questions about the seating, the issues under the heading of seating.
Go ahead.
So I was a little unclear as to what you meant by, on the third sentence, fourth sentence under that section, you wrote, the court will determine with counsel from both parties the number of seats they wish to have assigned to them in the public gallery, if any.
Were there any need, for example, are you going to ask that I reserve 2 spots for any additional support staff, for example,
I see.
that can't fit at the 2 tables that I have here?
Okay. Okay.
That's what I meant by that.
Okay. And then could we just understand the reserved seating arrangement and make sure that I understood what the court was saying? So you have indicated the first and second row behind the prosecution table will be reserved for victims. First row behind the defense table will be reserved for the defendant's family. Last row in the gallery will be reserved for the media. So I assume that means both sides of the courtroom for that.
Correct.
And that would mean the benches in between, which I'm counting, we've got 4 on each side, right?
Correct.
So like on the defense side, benches 2 and 3 are just general seating, general admission. Right?
Correct.
Okay. And row 3 on the prosecution side is general admission.
Correct.
If victims come and there's not room for them in rows 1 and 2, and there's space in those benches, may they sit there if there's space?
After 15 minutes,
Okay.
after the start of each session in the morning and the afternoon. I'm told that there are ample arrangements made for the victims to watch the proceedings in what was courtroom 115, that it's completely been renovated for that purpose. So we can't fit every victim in this courtroom.
I certainly understand that, Judge. I just wanted to understand, if there is an open seat and there's a victim that wants to be present in the courtroom, they may sit there, assuming it's not being used by someone else.
Absolutely.
Okay, and then
And let me also add, I have no idea how many media are going to want to watch. They're going to get the jury assembly room. They may all watch remotely. They have the media room that's in the back. If it becomes apparent that they only need one row or a portion of a row, I mean, we'll adjust.
Okay.
So, but at least wanted to do something so that when we come here on the day of trial, it's not chaotic.
I really appreciate that, Your Honor, and I understand you have a lot of interest to balance here, so thank you for doing that.
I appreciate that because I do have to balance victims, the right of the public, the right of the media, and the defendant's right, and anyone who's associated with those groups.
Sure.
And as you know, there are 8 rows that I am limited
Yes.
to in this courtroom, so.
Yeah. I just also had to ask one other question about the part about, once seated in the courtroom, spectators may leave, but they will not be permitted to re-enter until there's a break.
I want to limit distractions in this trial for our jury. I understand people may need to get up and use the restroom, but they're going to have to wait to come back in. That's for everyone, media, otherwise. I'm
Right.
trying to avoid all the coming and the going.
I respect that, Your Honor, and that's certainly a legitimate goal. I think even the attorneys find that distracting when that door is opening and shutting all the time. My question is, and again, a lot of it depends on timing, right? But I mean, usually we'll be taking a break around 10 o'clock, 10:30 somewhere each morning, right?
Correct.
If in the next sentence you wrote, the sheriff's department can use discretion in enforcing this. So obviously we don't want people jumping up every 5 minutes to get a drink of water, but if a victim or anybody would be upset by the testimony, and we've already told you there's going to be some very disturbing images shown, and they would choose to step out, because that's what we'll tell them also, right, is we don't want overt displays of emotion in the courtroom as well. And that happens at 8:45, and then we're not taking a break till 10:30, but by 9:15, they're feeling better. If there's a seat open and it's not disruptive, can they quietly come in and sit back down? I know I'm asking you hypotheticals, basically, but I just want to, give that example of, we agree, we're not
I will
going to
ask
ask
the
people.
sheriff to use common
Okay.
sense when allowing exceptions to this. If it's not going to be disruptive, if it's one person, if 5 people get up and leave and 5 people want to come back in, that's a different situation.
Sure,
It's a lot more noise,
Yes.
shall we say.
Yes.
So,
I agree. It's just, I mean, with the nature of the testimony, like if we're talking about a particular victim's injuries and that family happens to be here and they want to step out, but then we move on to a different witness and a whole different area of testimony, then they may want to return if it's reasonable. And if it becomes burdensome or disruptive, then I'm sure the court will let us know, and we'll,
I presume you'll have staff the victim witness room, that's the conference room attached to the courtroom as well. They always have that option as well.
sure, okay,
So,
thank you very much.
you're welcome. All right, Attorney Perry, have you had an opportunity, you and co-counsel, to review this?
We have, I would ask, this relates to something that was just talked about in terms of the court determining with counsel number of seats wish to have assigned in the public gallery. I would ask that we do have a few, and that those people from our staff be permitted to use their computers, since it would be, here at our request and doing notes lights and things like that, and that as it relates to electronic devices earlier on.
Will any of them be at the table behind you? Because we do have that option as well.
Yeah, it's possible that one person will be, but I'm anticipating in terms of other staff sort of being able to attend parts of it and assist us with parts of it, that I wouldn't want just like, different faces here throughout the trial. I want, some consistency with that.
Conceptually, I don't have an issue other than the computer. I'm really trying to limit in the gallery. As you can see, for example, the still photographer, there will literally be a chair on that end, like closest to Deputy Reinders, literally right behind him over the gallery, that says still photographer with credentials and an actual camera. No one else should have a camera in this courtroom. Okay, and that's to be very strategic on my part and make sure it's something that, if need be, the sheriff can also enforce. I can make arrangements, Attorney Perry, if we have, the Zoom will be up because of the live stream, other than during jury selection. And if because of the staffing in your office, if you need someone remotely to be able to monitor, I can make arrangements on, they have to keep their camera off, stay muted, but they can do that and no one would be, other than me seeing who's in the Zoom, would be none the wiser. So I can make that accommodation. Otherwise, if they're on a computer, they're gonna have to be at the table behind you. Now, if there's other people from your office who would be taking notes or something, that's absolutely fine. I would just, because of the way I have this order drafted, I would need to reserve those spots somehow, probably with an X reserve for defense team, so that they're not taken by other people. Would 2 be sufficient?
Yeah, that'd be fine.
All right, think about it. If you, I can always add to it. We'll put 2 reserve spots at this point. We'll have to mark those somehow, Teresa. And then if you think there's more, otherwise, computer will have to be at the table or through remote.
Okay.
And if there is something we can do in terms of another conference room at the courthouse as well, so that that person's closer, let my staff know, and we can work with the clerk of court's office to find you something if that would assist as well.
Okay, thank you.
All right, well, then I will finalize this, then there really were no changes to that, and we'll get that out so that the media can get that as well.
Your Honor, as part of that, did you want to consider my request about broadcasting victims and witnesses' faces on TV while they testify? Or would that be a separate order?
I would probably want to put something in, or at least supplement it at a later point in time, and you're solely talking about the broadcasting, right, of while a person is actually testifying.
Yes.
Anyone who's been named in the victim key.
Well,
Or-
and witnesses.
Well, what witnesses though?
Citizen witnesses that are not victims, but were present and observed.
I don't believe I have any grounds to do that unless they're named in the victim key and could address their privacy concerns that have been addressed right in Marcy's law, but
Well, there is a Supreme Court rule on point, Your Honor, 61.11, that says the judge may, for cause, prohibit a recording of a participant, and specifically talks about cases with, criminal cases with victims or police informants, other witnesses, things like that. It does give the court the discretion. It says the trial judge has broad discretion in deciding whether or not a prohibition is appropriate. For the victims, I think absolutely, Your Honor, their right to privacy, the victims that have to testify in this case, and we can identify who's a victim and who's not, that because of Marcy's law and Chapter 950, that order should be made by the court. As far as, again, citizen witnesses, we have been asked by a number of individuals for requests on their behalf for that order. They understand that there's a lot of media attention to this case, and they understand that the proceedings will be live streamed, and many of them have expressed concern about having their images, on the internet and made widely available to the public. So certainly their voices can be captured. I think even perhaps their names, they're going to have to state their name at the beginning of their testimony, but the request is that that their faces or their image should not be broadcast. So if the camera can focus on their hands or I don't know.
Well,
I'm
I'll
not
take
the
it under
cameraman.
advisement, and here's why. I would like to know the legal authority you're relying upon. I think I owe it to the media that's reviewing this to weigh in if they so choose, right? There's a constitutional right of the media to not only to be present, but freedom of the press. This is an open courtroom. Anyone walking in is going to see these individuals.
Yes.
And so I'll take it under advisement. We'll have some time before the start of testimony for me to rule on this. I certainly am interested in what the defense position is. There's a logistical issue because I am live streaming it through my platform and these 4 cameras. I am not going to be spending my time babysitting the cameras. I'm just going to be blunt. I need to focus my time and my energy on witnesses, on the evidence that's coming in, ruling on objections. And so I don't want to be tasked with that and then violate my own rules, shall we say.
Sure.
That's not to be insensitive. I understand. I think there could potentially be different categories if they are a victim and a victim is a little bit broader than being in a victim key, because obviously certain victims are deceased, and under the statute and under the Constitution, if a family member needs to testify regarding that person, right, and what happened, they would be considered a victim under the statute. And so I think it would be best if you flesh out for me what exactly your request is, who these individuals are, even if you do it by category,
Okay.
and the legal basis for that. I'll give the defense can then see that, and I'll have to give you like a deadline for that so that they can file any response as well. And then we'll just have to decide it. I'll have to decide it before we take testimony.
Okay, thank you. I understand.
All right. Thank you for your understanding. Have we gotten that? Were you able to get hold of Lauren? Okay. All right, well. Okay. So the letter did go out. You'll see what's in there. I did work pretty diligently on that to make it relevant and not change it. You'll see what's in there. There's a lot of, but at least you have that information so you know the jurors receive that. I've already talked about this. I don't have the voir dire script finalized yet, as is my standard practice. I will finalize that closer to the start of the trial and then email that to the parties. And then before going through that, you'll have an opportunity to tell me any objections or concerns that you have regarding it. I will be as thorough as I can, though, and if there are any specific follow-up type questions, even based on the questionnaires, we've already talked about that, but let me know, and I'll include that when I do that questioning. I'm going to save the motions and eliminate till the end and get through all the other issues that have been raised either in the email or by the parties here today. think I've gotten through all of mine. Attorney Perry, I don't know how much I can give you in terms of the schedule. I think the state, given the stipulation, is going to revise its witness list, and I'll just rely on the parties to work offline to meet and confer, and maybe they'll give you a better estimation of when they start their case, how long they think it will last. I understand experts have limited schedules, but we need to avoid as best as we can any significant, right, interruptions or delays where we're not taking testimony. So I don't need to know at this point what days your expert is not available. But I trust that he'll be available at the very close to when we need him, whenever that may be.
I have those days. I'm happy to share it unless you just simply don't want to know.
I don't need to know at this point. We can touch on that when we start the trial, and as I'm sure as each day goes on, we'll get an update. I'm not going to ask you every single day, but Attorney Opper tells me I think I can get this case on in 2 weeks, and we're at a week and a half, and I ask her, where are you at? And she goes, well, I'm going to wrap up tomorrow. I trust she'll tell us appropriately when you're getting close.
I absolutely will. I want Attorney Perry to have his expert present and available. I can tell the court as we sit here right now, we think we can present our case in about 5 to 7 business days. So I was going to tell the court that as well for jury selection purposes. I know many potential jurors were concerned about the length of the case, especially with the stipulation we were able to reach that helps tremendously, cutting down on those foundational witnesses. So we're projecting 5 to 7 business days for the case in chief.
All right, that's helpful. I think I can answer one of your questions. I truly believe, based on the jury questionnaires, based on the script that I've utilized in past cases and what I am putting together for this case, and even with the follow-up that needs to be done, I truly believe we can have a jury the first day. And even if that means we go a little bit late that day, I'd rather go till 7, 8 o'clock at night on the first day and get a jury. If that means we start a little bit later the next day to, give the parties appropriate rest that they need and prepare their, or tweak, maybe finalize their opening statements. If we get done that day, we'll start the next day, even if we get done a little bit early, right? We'll either get done early, we'll come back the next day for opening statements. We get done late, we'll come back the next day for opening statements, and obviously opening instructions ahead of that. So if we end up needing 2 days or 3 days, we could find ourselves in a position where it's the middle of a day and we finalize getting a jury. I think it's reasonable, either we take a significant break at that point. If it's an early lunch, we take an early and extended lunch. I'm going to be mindful of everyone's time and energy, and the jurors who have just sat through jury selection, right? Take a little bit of a break. It may be, given what the state's telling me now, I say, you know what, I'm going to give you guys the morning to prepare. We'll come in and we'll start at 1 o'clock. I'll be reasonable. I'll listen to your requests. I'll keep it moving along, but understanding there's going to be times, I think, where we need to take some breaks. Having done, presided over a number of cases, some of which have some really difficult testimony to sit through on all fronts. Sometimes we just need to take a break and come back. That's not to say we're going to do that every day, right? I mean, we have our typical breaks, our mid-morning break, our longer lunch break, our mid-afternoon break. That is what everyone should plan on doing, unless something unique happens that would require us to adjust. But we'll keep going within reason. I wish I could say something more. For example, if And we could play the what ifs all day long, but if the state gets done on a Friday morning, maybe it makes more sense to break and come back Monday fresh with the defense case, right? Things of that nature. If we get behind it anyway, then all bets are off. Then we're going to push forward. But I think from what I'm being told, the state's really been able to narrow some things down based upon the stipulations. So I appreciate both sides working together. And, you know, we'll go from there. Best as I can.
No, that's helpful, Judge. That's the kind of thing I meant. It's like if we finish at 3 o'clock, what jury selection are you gonna say? Okay, openings, or are you gonna say 8 a.m.?
I promise if we
I get
get
it.
done at 3 o'clock, I will tell you the next morning.
Okay,
You can hold me to that.
okay,
So,
thank you.
all right. Any questions from the defense on any of that?
No.
Okay. I think that covers the defense issues. We just talked about scheduling. You said you'd work on the discovery issues. If there is anything that impacts this trial, please let me know sooner rather than later. I'm happy to get involved even off the record if need be. I don't know exactly what you are referring to, but I trust it's not anything that's going to hold up our trial.
I don't think it will.
Is anything you want me to know today?
I think we should first follow up with the state, and then if necessary, we'll bring it to the court's attention.
So you don't, nothing you want to bring up today?
Right.
Okay, fair enough. Okay, so Attorney Opera, you referenced a couple of other issues. One of which I already took under advisement. I think I addressed the timing. I think that leaves the face mask issue that you wanted to bring up.
Yeah, there's a couple other things here on my checklist, Your Honor, but we can go to the face mask issue.
All right, go ahead.
It's appropriate. Your Honor, I have a request as to Mr. Brooks wearing a face mask at all times in the courtroom. Frankly, I'm not sure the reason behind that. I guess it really doesn't matter, other than to indicate there's certainly no court order requiring that, nor is there any requirement by the sheriff's office that he be required to wear a face mask in court. My concern is that identification of this defendant may be a significant issue in this case. The jury will be shown multiple videos and photographs of the driver of the SUV throughout the trial. They will hear testimony from eyewitnesses that we believe will identify the driver of the vehicle, but ultimately, that is a question they will have to be concerned with themselves and be convinced beyond a reasonable doubt that Mr. Brooks is the person who committed these crimes that he's accused of. And with the face mask that he's been wearing to court, I think almost every time, if not every time, I think impedes that ability of the jury to reach that conclusion as to identification of the defendant. So my request is that he not wear one, but if there's some legitimate reason or medical reason or need for the mask, then at least there has to be appropriate lengthy occasions where the jury again can observe Mr. Brooks at the defense table and assist them in making that conclusion as to his identification. So, I mean, if this trial lasts 3 or 4 weeks, I don't think 5 minutes is a fair compromise there. I would be asked that he be required to be without the mask for some substantial period of time, again, so that the jurors can observe him. And many of the recordings and photographs are quick screenshots and very short in duration. So it's not as if, we have a portrait that we could say, here's the portrait of the driver and here's Mr. Brooks, and you could just have him take off his mask for 5 minutes and that would be sufficient in our opinion. So that's our request, is that he be ordered to remove the face mask for the whole trial. If the court won't go that far, then for at least sufficient amount of time for the jury to reach its own conclusions. And obviously, he'll have to do it temporarily when the witnesses are asked to identify him as well.
Attorney Perry, I know there's not a written motion on this, so if you need some time to think about it, if you're prepared to address, great, I'll turn it over to you, but I know I'm first hearing this. not a surprise, I would say. I had thought about some of the identification issues and how would we do that given the mask, but how would you like to handle that?
Well, I am surprised at the request that he be not permitted to wear a mask at all during the course of the trial. It's one thing if it were tailored to a particular witness, their described ability to perhaps identify him, and if needed in a particular moment, to take it up that way. But I mean, surely this isn't, we aren't so far removed from COVID that it's a mystery as to why somebody might be wearing a mask. Mr. Brooks has been consistent, I think, you know, at the jail in court with being masked. You know, it's not at all uncommon. I think when we walked into the courthouse today, there was somebody at one of the security persons wearing a face mask. That's still it's less and less common, but that's still the world we find ourselves in. And for him to be taking those precautions to remain healthy, which frankly, with this desire not to have any delays, is, you know, kind of would assist with that. So I would certainly object to any just blanket ruling that Mr. Brooks not be permitted to wear a mask. I would think that anybody in this courtroom should remain permitted to wear a mask if they felt that that was necessary for themselves without having to provide, you know, a doctor's note or some special circumstance to permit that. So I guess I think that's how I'd ask that this be handled is, you know, if it's a, you know, if there's testimony that, you know, I saw Mr. Brooks face on, and, you know, in order for me to identify him, I would need to see his full face. I think, you know, we should address it that way in the hearing, and we can be on advance notice that, you know, for the minute that's necessary, that he, you know, expose his face to a witness. But I would absolutely object to an order that if myself or Attorney Keyes or Mr. Brooks wished to wear a mask in a public setting, if one of us were feeling symptomatic or nervous about whoever's at home, you know, we haven't been wearing masks, but Mr. Brooks has. I would very strongly object to an order that he not be permitted to wear a mask during the trial.
I am not at all interested in delving into any personal reasons why a person would want to mask or not mask. I am concerned, however, about the ability of witnesses to identify Mr. Brooks when asked to do so, and ultimately the jury making a determination based on identification. I do not believe that a blanket rule of no mask is necessary to do that. I think it's appropriate that Mr. Brooks be required to unmask anytime that a witness is being asked to identify him, and to do so for an appropriate amount of time. I don't know how many witnesses will be asked to identify him, but if there are, you know, 75 witnesses and 50 witnesses are being asked to identify him, and each witness were asked to see him for at least a minute, 50 minutes is not an insignificant amount of time. I might also entertain a request that at least during some of closing arguments, that he remain unmasked, so that the parties can make appropriate arguments, and the jury can make begin considering those things. Of course, they don't deliberate until they're in the jury room. I'm open to other means. I don't want to presume to know what types of photographs are coming in or evidence, but if it becomes appropriate to, for example, a booking photo, because that is unmasked and that is something that witnesses are also shown, that might be appropriate in light of his desire to remain masked. Ultimately, Mr. Brooks, what you need to know from me is that I will be asking the jurors during jury selection process about masks. I do that in any event. It's not special to your case. We have jurors who come in with masks. We have jurors who come in without masks. When witnesses come to the witness stand, I require them to unmask for purposes of their testimony so that the jurors can judge for themselves the credibility. I think that's important. So if you take the witness stand, for example, you will be required to unmask. And so you just need to be aware as you make your personal choice about whether to mask or not, that in some respects it will have to be highlighted to the jury, even if it's with a question to them about that, not specifically as it relates to you, but there are some general questions in the voir dire script about that. And of course, temporarily unmasking for purposes of identification, and then perhaps an order that you unmask for portions of closing arguments. And again, and if he does choose to remain masked, then I would also entertain a request from the state, if you aren't already planning on using a booking photo or some other photo where he's unmasked to assist with identification. I think that's something I would entertain as well.
Understood, thank you.
All right, what else is on your list that I haven't gotten to?
The jury view,
Oh, yes. Thank you. Too many things I crossed out. I didn't cross it out, but it looked like I did. I know that the state has withdrawn its request to do the jury view of the parade route. I did receive that in writing. There is, or maybe it was orally, I don't remember which anymore, but you did file a letter regarding the jury view of the SUV. You put together some parameters. I've reviewed that. Has the defense had an opportunity to review that as well? Any objection to their proposed plan?
Yes, we were much more in line with what I thought the court had suggested in terms of if that were to happen, that it would be at an impartial or as impartial a setting as possible. I thought that there was the suggestion that was a very good one to take place at the county grounds as opposed to just right at the sheriff's department. So that's the basis of our objection to that.
Attorney Opper, you want to be heard further?
yeah, I guess maybe I wrongly assumed everyone would be familiar with the area, and that probably wasn't fair. It's nothing more than a garage. It's indoor. It's attached to this building, I believe, or would be, I'm told, easy for the sheriff's office to get Mr. Brooks to this location safely outside the view of the jury. And it would also be relatively easy for them to transport the jury to this location, relatively easy. There will be, I mean, other than knowing that they're going into another garage area connected to this building, they'll know it's somehow associated, I guess, with Waukesha County government, but there will be nothing in there saying this is the Sally Port to the jail or the entrance to the jail or sheriff's department, anything. What I was told is that anything that's in there can be removed. They would just simply feel like they're walking into a empty garage.
Given what I know about the Sally Port and essentially the offer of proof that was put forward by the state in its letter, I'm going to approve the jury view. What I'd like to do when we get to that point, and once that is set up, to at least give the attorneys an opportunity, and perhaps with the court, just to walk through it, to confirm everything that the state has just said. Certainly, if there's an objection, Attorney Perry, you can still lodge your objection. But I think given what the state has outlined, given some of the logistical issues that this court will face in that type of jury view, and frankly noting that since the state has abandoned its request to do the parade route view, there's really no need for us to go far outside this building. The Sally Port would be secure. It would address the security needs and interests of the sheriff. It would provide an opportunity for all parties, including Mr. Brooks, to be present, and for the court as well. I would direct the parties' attention. There is a jury instruction. I don't have the number on the top of my head, but there is a jury view instruction. You should review that if there are going to be any modifications to that, or if it needs to be personalized to this case in any way, that should be done ahead of time. And again, to give the attorneys an opportunity to at least view it ahead of time, and bring any final objections to the court regarding it, but at least as proffered and as laid out, I will approve that. I think that's appropriate. Okay, I believe we are to the motions in limine then. Anything, Attorney Opper, or did you have something else that I
Yeah,
forgot?
you missed also number 5 on your own list about the preliminary jury
Oh, I
instructions.
did. See, this is what happens when I cross out my own things and I think that's a big one too.
That's Miss Bailey's issue. You're on it.
Thank you. All right. Thank you. Thank you. Yes. So jury instruction 116 deals with multiple charges for the same offense, different victims. I have done a significant amount of work to prepare these jury instructions. Conceptually, you have everything that's there. There's some counts that need to be added in. But I believe jury instruction 116 is very instructive, especially the comments. Hopefully you've all had an opportunity to review what I've drafted, so we can talk about the grouping of the jury instructions from the state.
Your Honor, I have, and I would agree with the use of 116 as it relates to the first degree intentional homicide, the recklessly endangering safety, and the hit and run causing death. I guess when it comes to the bail jumping, I know that the state submitted 2 different bail jumping instructions. The difference between the 2 of them, and I believe the first one submitted referenced the charges in Milwaukee County case number 20 CF 2550. And the second one, which would be page 14 of 18 that the court or the state submitted, reference the charges, the felony charges in 21 CF 4596. Because there are really 2 different elements based upon the 2 cases that he was pending on, I think that those do need to be done separately. I would note that in the court's instruction, I think you included second degree recklessly endangering safety and felony bail jumping. So it could be, I don't know if the court caught that there was different charges.
I may not have.
Okay,
That was late in my day on Saturday.
so that would be my one comment. The other comment would be on the 2 batteries.
Can we just go
I'm
back
sorry.
to 116 and the bail jumpings though
Okay.
for a second? And let's just jump to that outside of the grouping. Because I probably overlooked that there's only one case that has the no contact with, right, victim PPP, or
We're not even charging. I think we are just saying that he committed a new crime.
the complaint says otherwise.
The information, I think, is what I was looking at, and let me take a look at that.
I'm looking at the information, they're pretty general.
And actually, I did choose in the jury instructions to be more specific. We are alleging that he committed a new law violation.
But do you see in the second amended complaint where you have both?
Correct. And I do believe we have to choose. I mean, frankly, we could have charged one count. We could have charged more additional bail jumping counts. What we've decided, and I think the information is the charging document at this point, which leaves that unanswered, is that how the jury instructions were that I submitted. Actually, on page 2 of the jury instructions that the state submitted, 1795, it says that the defendant is charged with violating a condition of bond that required that he not commit any crime. The state alleges that the defendant committed the crimes of. Again, we can file an amended information that would specifically allege that, because I think we have to choose the theory. That is the third element.
I don't disagree, it's just because the charges were so general, I looked to the second amended complaint for notice on what that would be, and at least as it relates to one of the cases, he had a no contact with victim, I think it's PPP. So I'm asking you whether it sounds like you want to maintain a new crime for both of the bail jumping. Or do you want one to be he violated by having contact?
No, we do want the new crime for each of them. And again, if the court would like us to file an amended information that conforms to that, because as it stands, that's what we're going to argue at trial. And I believe that the information could have been amended at that point. I believe it probably in fairness to all parties, just so that they know instead of, it could have been any condition of the bond, that we are arguing a specific condition.
So that leads to my footnote about jury unanimity. And normally, when you allege, and when I instruct a jury on a bail jumping based on a new crime, you repeat the elements for the offense that you're claiming he committed in order to form the basis for the bail jumping. Now, there's some very good language in the jury instruction as well on bail jumping, and I've repeated it in my draft, that says the crimes of first-degree intentional homicide, use of a dangerous weapon, read them all in, have been defined for you, and you should apply that same definition here. The issue is when you get to the jury decision, do they have to be unanimous on what crime was committed? Or can they, or like, for example, in the failure to render aid in the duty section, they have to find that beyond a reasonable doubt that a duty was violated. But the jury doesn't need to be unanimous on which duty was violated.
Correct.
And so I didn't do any type of deep dive at that point into the law further. I just noted my concerns in basically referencing, groups of charges as you had asked, and then
Your Honor, I think their finding is that they have to show, or they have to find by majority that he committed a crime. It can be any crime. They don't have to agree, I don't believe, on a crime that he committed. As long as each juror comes to a decision that he committed a crime, that's a violation of the bail bonds. That I don't think has to be specific.
I think this jury instruction needs to be modified in order to make whatever I decide clear. If it's unanimity on a crime, again, I didn't do a deep dive into that. I don't know, Attorney Perry, if you have any thoughts on this. And just kind of focusing on these 2 counts of bail jumping, I would agree. Given the charges, I don't need to group them, and I can, if I have to read those elements a second time, that's really not that big of a deal. We're talking 2 charges of bail jumping, but on this issue of the state electing a new crime, and this, what I think highlighted as a potential with the instruction, a potential error with the instruction.
I haven't been able to do a deep dive into this, so I guess if the state, not entirely clear, if the state intends on suggesting different language or what it already had suggested, which is the state must prove by evidence that the defendant, and then just list out the different crimes that are charged. I recognize, I think, the problem flagged in the footnote, which is, it's more than really an aspiration, right? Is you want unanimity as to the findings that support a verdict in each case on each element. And I think that's, if I'm understanding the court's concern correctly, in the footnote.
I had actually come up with a sentence, and I didn't include it here, somewhat based off of the failure to render aid instruction when it's talking about the duty that's violated. It says in that, I think it's under paragraph 3 of that instruction, the state is required to satisfy you beyond a reasonable doubt that the defendant violated at least one of the 2 duties, but you are not required to agree as to which duty was violated. And so something along the lines of the state is required to satisfy you beyond a reasonable doubt that the defendant committed, is it one of the crimes listed or a crime? But you are not required to agree as to which duty was violated. Again, I don't know if that's legally, when you read the comments to the jury instruction for, bail jumping, you could probably go both ways. And one of my other questions to the defense is, are you satisfied that the jury instruction, at least as written right now, references the elements for those other crimes by saying you've been instructed on them, you need to follow them? Because I don't know that I've ever instructed a jury that way, not because it wouldn't necessarily be proper, but just because I usually have the time and it's a count or 2, and so I just reread the elements for that substantive crime. You follow me? I know it's a little convoluted, but
I think so. If what I understand the court's question to be is, do we think that all the elements, the instructions for the underlying crimes, need to be stated again at that point?
that's one question, yeah.
And with the court's earlier comment, from the probable cause section of that second amended complaint, I hope I'm referring to the right document. It was our understanding, in terms of the description of the bail in the second case, that the way it had been, that the allegation, certainly in referring to the no contact provision, that is what we were anticipating that second count of bail jumping to be alleging, because of the charging language in the criminal complaint. I guess I think at this point I would request that the jury be given full instructions as to the different, if the court is, if that's how it's proceeding in terms of the first count of bail jumping and the second count, I think that the full instructions really should be given in terms of the substantive definition of what they think the crime is that supports it.
Both times.
Well, again, no, I don't think it would have to be back to back, because it's the same, it'd be the exact same theory. I mean, we do object in terms of, just on general notice, it was our understanding that it was an allegation of the no contact provision with victim PPP, based on the language in the probable cause section.
I'm going to take at least these issues related to the bail jumping under advisement and have the parties do a little bit more research and further drafting needs to take place. I was under a similar understanding as the defense, at least as to one of the counts of bail jumping. I would note the information lists the same date of violation, Sunday, November 21 of 2021, but it does say Main Street, which I will fully acknowledge that should have been putting all of us on notice that you were alleging a crime versus the contact, because I don't think the contact between the two, if you look at the charges of battery on both days, they're listed as being Frame Park. So I will acknowledge that at least the way the information reads, it would allege a new crime, while understanding the complaint said both, at least as to the bond in 21 CF 4596. And I'm looking at page 30, the first full paragraph, where it says Brooks made an initial appearance on this case on November 5 of 2021, and cash bail was set in the amount of $1,000 with the condition that he not commit any further crimes and that he have no contact with victim PPP. So state can elect, that's their discretionary decision at this point, their prosecutorial discretion to decide how to proceed, and obviously it'll be up to the jury on how to answer those questions. And so we'll look at this again before the jury is ultimately given the preliminary instructions. I think it best to allege to not group them, given it's the same data violation based on two separate cases, and that will be spelled out in those instructions. So I think that's best. I'm inclined at this point to follow the comment to the jury instruction on bail jumping and draft at least the way I have it right now about the crimes of first degree intentional homicide, use of a dangerous weapon, first degree recklessly endangering safety, use of a dangerous weapon, hit and run, resulting in death, and battery have already been defined for you, and you should apply the same definitions here. I think I can take out the battery though now based upon the charging language and the information, because the battery occurred at Frame Park and not on Main Street though, right? You wouldn't be alleging the bail jumping based on the battery then, because you said at Main Street in the charging language. Fair enough?
Yes. That's fine.
Right. I'll make that change. And then the big question will be then is what do I need to say in that instruction on unanimity? Do they have to agree on the same crime, and do they need to be instructed on that, or is it just they need to agree that he violated a crime beyond a reasonable doubt, like the duty in the failure to render aid? I'll let the parties look at that, do your research on that. I'll do some additional research, and we can obviously finalize that at the appropriate time. So that just leaves the other groupings with the intentional homicide, the recklessly endangering safety, and the hit and run. Does the defense have a general objection at all to the grouping of those and the use of 116?
No.
Obviously, what 116 didn't do is it didn't in any way address an enhancer or a special verdict question, and so I did my best. I think I did a good job, but certainly want to know from the parties what you think of how those were addressed in the jury instructions. And then there's just some other housekeeping issues like am I naming victims at this point or sticking with their designation and the victim key?
Your Honor, we were planning on naming victims in the final jury instruction.
Final, what about preliminary?
As well as the preliminary. And the victims are aware of that.
That would, thought you might be doing that. Any objection to that?
No, that's what we had, I'd hoped that these were just placeholders in the drafting of these, but I think that that's required actually, so, yes.
Great, then I will make sure that all the names are appropriately inserted. So let's go to page, if I have page numbers. It's under the intentional homicide jury instruction. So starting where it says 116, multiple charges of the same offense, different victims, counts 1 through 6. I've already answered the first highlight, I'll name them. I gave you 2 versions. Count 1 combined, where it says the first count of the information, it says Mr. Brooks is charged with causing the death of victim A with intent to kill, contrary to Wisconsin law. Then the separate paragraph, the first count of the information also alleges that the defendant committed the crime of first-degree intentional homicide while using a dangerous weapon, contrary to Wisconsin law. You look at counts 2, 3, 4, 5, and 6, I've combined them in the language. Everyone following me so far from the state?
I think it's on page 11 of 30.
I don't know why my page numbers aren't coming up, but okay.
It's on page 8 for us, but
It's right after the credibility.
I'm looking specifically at 11 of 30 when you're talking about use of a dangerous weapon and then going into the jury's decision.
Not the jury decision. I'm talking where I just list the counts.
Okay.
So I drafted the counts in 2 separate ways, which I think is page 8.
Yeah.
Basically, if you look at where it says the second count of the information, in this case charges that, it just says with intent to kill that person, comma, and while using a dangerous weapon, and then it lists all of the statutory sections. Whereas above in count 1, I've split out the charge of intentional homicide and then the enhancer for the use of a dangerous weapon. Anyone have a preference? I think both ways are okay, but I wanted the parties to specifically weigh in on this from the state.
Your Honor, I guess I would, either version is fine with me, so whatever the defense would prefer.
All right, Attorney Perry.
I guess I would prefer the first version.
Where it's separated out.
Oh, you know what? Hang on just a second. I'm sorry. No, I guess I said that the opposite of the way I wanted.
That's
to.
okay.
So the second would be our preference, just
Okay.
that for consistency.
Okay, then I will change count 1. I will make a note to myself. I've highlighted it in my version, so that tells me I need to change something.
And Your Honor, so under the jury decision, it will read as it reads, and that's on page 11 of 30. If you find the defendant guilty of count 1, you must answer the following question, yes or no.
Yes,
Okay.
that is correct.
That's fine.
So basically with 116, we list all the charges separately. So here 1 through 6, the substantive on the elements for intentional homicide and the use of a dangerous weapon are all stated just once. And then for the jury's decision, I actually broke them out with those headings, not to say that the jury even sees that, but for my clarity, I broke it down by count and then have the special question as to each count.
Yes.
Attorney Perry?
It's fine.
And then when we get to the next set of groupings, I didn't even, you can see I have the structure of it. I need to set forth the counts. I will do that just like I did with counts 1 through 6, where it's just one paragraph saying he's charged with first-degree reckless endangering safety, use of a dangerous weapon. There'll be 60 of those read. And then getting into the substantive where I needed to modify that was similarly to the homicide, use of a dangerous weapon, that's all in the substantive. And then similarly to the intentional homicide, each count then has, under jury decision, what I think are the appropriate instructions, and has the special question related to each. Any disagreement from the state?
No, yeah.
How about from the defense?
No.
Okay. Then we'll move on to the hit and run charges. So they're labeled hit and run in the information, but the jury instruction is failure to give information or render aid following an accident. So it can be described either way. I want to be consistent and just want to know the party's preference or request. State have one.
Right, I have one moment.
This is one of those areas where we kind of colloquially call it one thing, but the statute and the violation is a different thing. I think it's the difference between protect and the statute.
Go with the statute.
I started with the colloquial until I realized that, and that's when I jumped over and said, I need to ask the parties that. So I tend to agree with the defense on this one. State of any preference?
You know, I guess we would prefer hit and run, but in the end, I think that's how it's referred to. That's how officers refer to it.
I understand. I would agree, though, the
Right.
statute
Right.
refers to it as failure to give information or render aid following an accident. And so that's how the jury instruction reads. And so that's how I'm going to refer to the charges.
Actually, if I'm just looking, because Ms. Opper pulled it up, it does say duty upon striking person or attended or occupied vehicle is the label of that.
That's
The title of the statute.
I'm going to go with what my colleagues have described this offense in the jury instructions. A lot of thought goes behind these, and I think given the defense request, that I will label it as it is in the jury instruction. I don't think there's anything wrong with referring to it as long as there's some reference, as we sometimes refer to this as hit and run, but I think it's pretty clear based upon the substance of the instruction, what he's being charged with.
Because really what that's talking about is only the second duty. Okay.
I don't necessarily disagree with you. I'm just relying upon what's in my jury instructions. We need to have a discussion on whether it should be titled duty, whatever you just read, then that's fine too, but I need to know what the state's request is.
Thank you. We don't have any further comments.
You're okay with it, the way that it's written in the jury instruction then? Or are you making a specific request?
Well, Your Honor, I guess the specific request would be for it to follow the label of the statute. If anything, if not the hit and run, then duty upon striking. I mean, like I said, the failure to give information or render aid is the second duty. The second duty is that a driver involved in an accident involving a person or intended vehicle must stop and provide information or render aid. That only covers the second duty. The first duty is to reasonably investigate what was struck. So I think that the title of that is focusing on the second duty, it doesn't incorporate the first duty. And I think when you look at the title of the statute, which is duty upon, there's two duties.
Duty upon, can you read me that whole thing? I don't have it in front of me, but I don't have my statute books down
Yes,
here.
it's duty upon striking person or attended or occupied vehicle. And then I think it lists the duties that a person has.
I'm happy to change it to that if there's no objection from the defense. We have three options, I guess, at this point. One I've somewhat rejected, and that's hit and run, but failure to give information or render aid following an accident, or simply changing that to duty upon striking a person or attended / occupied vehicle.
Either of the second or third option is fine with us.
As I recall, my reading of the second amended complaint, would it only be striking a person? I mean, I'm just trying to limit what we have in the title.
Correct.
And so if it just says duty upon striking a person, would that
That'd be
be
fine.
satisfactory to the parties,
For the state, yes.
for the defense?
That's fine.
All right, I'll change that then. Let me just make a note to myself. So do you all see where I changed them or modified the substantive to add a heading resulting in death? Because that required the special question. So I modified the jury instruction to be consistent with the instructions in 116, understanding there's a special question related to ultimately to the penalty in this case, because it's alleged that the duty that was violated resulted in the death of a person. So I specifically added that portion of the jury instruction in. So it's between deciding about knowledge and jury decision, because I wanted there to be something in the body of it, since normally you would have that after the jury decision. It would just ask for that question, but I didn't necessarily want to read this 6 times. And so that's why I did that. Is that satisfactory to the parties, to the state?
Looking at my proposed right now, I'm checking it over. Yes, I think that makes sense.
How about from the defense?
I think that that's fine.
And then as you see, when you go down, each count then under jury decision has the special question in addition to the normal guilty versus not guilty language. And so do the parties agree with how that's worded, understanding I'm going to change the highlighted section to what we discussed here today from the state? From the defense?
That's fine.
Now, the last 2 charges then in the jury instruction would be battery. I grouped them together. Actually, I didn't group them together. Let me look. Maybe I did. I might not have the heading in. Oh, I grouped them together. I think in your copy, I had a typo. It said bail jumping still, and it should say battery. I caught that after I emailed it off. So it's right above the heading battery.
Oh, right. That says that you're using 116.
I'm using 116 again.
And that one I just felt, because it's two different dates of violation, that it might be better separated. Because
But
it
the
is same
counts
victim.
will say that. The counts will say the dates when they're just not included in here because I just frankly ran out of time. But each count then will say the specific date.
The counts as it goes under the jury decision or the verdict forms?
Well, so first of all, you have to go right under 116. It says the 76th count of the information in this
got it.
case charges that. I just don't have it in there because I
Got
ran
it.
out of time.
Okay,
But that's where you'll see the date and the location, okay? And so then the 77th count would have that separate date.
okay, so it would read under that, charge that on November 20th, 2021, okay, and then, that makes sense.
And then because I'm grouping them as to each count, language is in there. And then when you get to jury decision, they would refer back to, of course, that, and this is just for preliminary again, but nonetheless important. It references each particular count.
That makes sense.
It seems like, I know it's not a lot that I'm saving, but I am saving a little bit. And to be consistent with the grouping I've done with all the other ones, I thought it was important to group here. Any objection from the defense to that grouping?
No.
And again, once it's completed, you agree to it? You agree to it?
Yes.
Okay. Were there any other instructions that you think should be in the opening instructions that are not?
Not from the state.
Okay, then I will finalize all of these, and when I get it done, I'll send it to the parties for a final review and then a final determination before I instruct the jury. I know we need to get through the motions and limine quick. I need a 5-minute comfort break before we do that, so I'm just going to I'll keep the live stream on. The audio will be muted. Mr. Brooks, if you need to use the restroom at all, please. If anyone else, I will be back just shortly. We'll just take about a 5-minute break. Just a reminder to anyone sitting in the gallery, because my live stream is still running. If you get up and down, you may be inadvertently captured, but it's just easier for me if I do that. Okay, thank you. Yeah. Right. Okay, great.
I think it could go an inch one. I think you're going into the other way, just a little. It sounds like the way things when you're taking a picture or something. No.
All right.
Thank you. Please be seated. Before I get to the motions in limine, I did forget to cover the supplemental questions from the defense for court-led voir dire. I don't know if the states had an opportunity to review those. Couldn't even tell you what document number it is because the version I have is not from the e-filing, but
Document 217.
any objection to any of those? Some of them are topics I cover in other respects, so I don't typically duplicate, like I always ask about being victims of crimes.
Right, and I kind of figured most of these would be included in that already. So, no. No objection.
Attorney Perry, if there are ones that are in my normal script, you agree I don't have to duplicate them?
Right.
All right, but to the extent that they're additional, I'll include these as well.
Okay, thank you.
You're welcome. I didn't miss anything from the state in that regard, did I?
You do not?
Okay, great. Okay, then I think we are ready to move on to the motions in limine. The state, I believe, has two separate filings, one from August 1, one from September 2nd. And I believe the defense just has one from August 30th. Am I missing anything from the state,
No,
from the defense?
No.
Okay, good. All right, then I'll start with both of the state's filings and I'll ask the defense if there are any in particular that you disagree with and that I need to specifically address. Noting that I believe number one on their motion in limine, I would have already addressed with the specific motions that I dealt with on in late August.
I think that number 8 is something that we'll have to get a proposal on and make a decision, but we don't have an objection.
I had a note on number 8 that to ask the parties if the state has gone through their witnesses to identify whether anyone has a prior record and to provide notice of that to the defense.
Your Honor, I can tell the court that we are just narrowing down our witnesses, and once that is decided, which I think by the end of this week, we've been collecting dates of birth from everyone, and we will run those and provide those to the defense.
I would think it would be reasonable to the parties that once that is done, and of course for any defense witnesses as well, that the parties meet and confer, notify the court of any stipulations and of any disputes. Do you think that can be done in writing by the 26th? Anyone have a problem with meeting that deadline?
I don't, so would that give us a week?
If you need more time, just tell me. It's just a date I threw on my notes.
Friday, that Friday of that week?
These are notes that I made when we had the jury status on the 9th.
Yes.
So
If we can do it that Friday of that same week, which would be the Friday before the trial commences, I really don't think that there's going to be issues with regard to agreeing to prior conviction.
so the 30th,
Yes, please.
any problem with that?
No, the 30th. would be better
Okay.
for us.
That was the one thing I didn't change any dates I had in here. Probably should have done that. Other than that, anything specific that the defense wanted me to address? I do have notes. I mean, I can brew on each one if you want.
I didn't understand number 21, but I don't think we have an objection to it. Just not sure what the state is getting at.
I had a note to myself, anything specific, so I get what you're saying. Anything specific the state was referencing in 21.
it really doesn't apply too much to this case. It's meant more for other cases where there's other investigations or I guess ancillary matters, outside the scope of this case. So no, I can't think of any specific example in this case.
Judge, I think on number 23, I would, I don't have an objection, except I would add the caveat that unless the rule of completeness would say otherwise.
I would tend to agree with that from the state.
Sure, yes.
As to the second motion in limine, I do object to their number 1. No objection to the second.
All right, so let me just generally, and we'll end at least on the state's motion with discussing number 1 of the state's second motion in limine. I went through all of these motions in limine. They all seemed pretty straightforward and appropriate. One I already addressed with specific motions regarding the statements made by the defendant. So I'm not going to add or otherwise limit already what I've already ruled upon. 2 is advisory. 3, 4, 5, all concern phase 1. The NGI plea has been withdrawn, but the prohibitions nonetheless would apply because they're not relevant even in a phase 1 or trial that we're having on the issue of guilt. And so that limits the introduction of mental health history as outlined in 3, 4, and 5. So I'll grant those. Looks like both parties are seeking exclusion of witnesses with some caveats. I think exclusion of witnesses is appropriate, even if the person is a victim until their testimony is otherwise completed. I need to balance a course of victims' right to be present with the right to a fair trial. And unless there are any specific requests that will be made to the court that I need to address, any victim who's also named on the witness list will be excluded from admission to the trial from watching it until such time as their testimony is concluded and they've been released from their subpoena.
Have you heard on that, Your Honor?
Sure.
Well, I guess my concern is this, Your Honor, is that the scope of this trial, right, the length, I mean, I can't put everybody on the witness stand the first day. That's going to have a drastic impact on the victim's ability to watch this case. Those that may be asked to testify on the 7th day of the state's case, that will mean they could not attend this trial in any capacity until that time, and that's really unfair. I think that really is a violation of their right to attend the trial under Chapter 950 and the Wisconsin Constitution. We understand the necessity for a fair trial. They can and should be ordered not to discuss the case with anybody else, not to talk about it amongst themselves on a break or in the witness waiting room or anything like that. We certainly respect that, but for a blanket order that they cannot attend the trial until they testify will have a very, very chilling effect on their ability to participate. I think it would be contrary to the spirit of Marcy's law, if nothing else. We can engage in whatever safekeeping we need to make sure that it's fair, but the statute specifically envisioned this competing interest essentially, and it's 950.04 sub 1B sub B and 906.15 sub 2 sub D that allows the court to have a victim present even though he or she may be asked to testify. It's just, it's not like a typical case, Judge, where we could put the victim on first or second. We have 100 victims. To ask that last victim who testifies to wait to the very end to attend the trial is wholly unfair. So whatever restriction or order you want to put on their ability to discuss this, I understand, but we do it with court officers, we do it with other individuals. There is some overlap, but to a certain extent there is not overlap. Like those who are in the 100 block of Main Street know nothing about what happened in the 400 block of Main Street as well. So a lot of it, maybe if the victim from the 400 block hears the testimony from the 100 block, it's really, the impact on their testimony would be so minimal because of the distance and the difference in the conduct and things like that as well, that I really would ask you to reconsider that and or give me an opportunity to present some written argument to you if you think that's necessary. But
I
those are my
understand what you're
concerns.
saying. I don't want to make blanket rules either, but I also don't want to make decisions in a vacuum. And I think it's important to know who on your list of victims who are scheduled to testify are actually making that request so that I can better understand and maybe evaluate exactly what you're just saying. Would they be impacted, their testimony that is, in any way by listening to the testimony of others? It may be that conceptually, right, you're asking me these things when in reality, it might be 1 or 2 or 3 people who are making that request in actuality of you.
Well, I can tell you just in my trial prep, most of the victims that we've met with have expressed a sincere interest in attending this trial. My comment to the court's inquiry is that I can tell you also, as an officer of the court, with very limited exception, every victim we've met with has said to us, it all happened so fast and they were just focused on their own family, their own child, nobody can tell this whole story, right? 3 people could be standing at the same corner and see 3 different things. And that's what we have encountered as we've spoken to dozens and dozens of victims over the last couple of weeks, that really they may say, oh, that's what that family experienced. Well, that's very different when what this victim experienced. And again, to the ultimate issue as to whether or not anybody's safety was endangered or anybody was killed by Mr. Brooks' conduct, very few of them can go there as to other individuals. I'm sorry if I'm not explaining myself well, but they were.
I understand what you're saying. I'll
Because
certainly.
it's such a unique thing. Everybody's first reaction is, where are my kids? Where's my spouse? We haven't talked to him and said, yeah, I think my kid was hit, but I ran down the block to look for other injured people to see what else he was gonna do.
I understand what you're saying, and as you noted, there are competing rights and interests that I need to weigh to ensure that there's a fair trial and to ensure that the least amount of errors are made, hopefully none, right? Because it's also in everyone's interest that this trial be done right the first time so that there's only one time. Let me hear what the defense has to say about this.
I think that the reasons we just heard are the reasons why sequestration is so important, in that if so many people can't tell the whole story and then they are hearing the rest of the story prior to their testimony, this is not the typical trial, is the reason why it makes it even more important. We heard earlier at this hearing about how many people would be asked to identify Mr. Brooks, and that's a component of, I haven't testified yet, but I've watched all these other people identify him in terms of the request to take his mask off and things like that. That's the concern that we are hoping to guard against with this request for sequestration. And in terms of Mr. Brooks' rights at this trial. And so we'd maintain that request that witnesses be sequestered until they're done testifying and released from their subpoena.
Thank you. I'm certainly well aware that the constitutional provision went into place, I believe, in March of 2020 or shortly thereafter. And we've had a statute that has many of the same provisions, but not a lot of case law. And so if the state would like an opportunity to present some additional arguments, I mean, it's also true, exclusion of witnesses, sequestration of witnesses, whatever the word we want to use, is really a bedrock of trials as well. There are some limited exceptions, and I fully acknowledge that under even that statute, a victim is allowed to observe the trial and be in attendance. But this is not your everyday trial, and I want to guard against just many of the things that the defense has stated as well. And I need to weigh and balance out these competing interests and the due process rights of Mr. Brooks, along with which is a constitutional right, embedded in the 14th Amendment, and of course our rights under the Wisconsin Constitution as well, just like Marcy's Law, as we call it, is a constitutional right. for the victims. I'll certainly take under advisement the request to do something less drastic and issue some other orders, but I'm not going to fully answer that today and give the parties an opportunity to weigh in writing so that I can look at if there is any case law that I might not be aware of sitting here right now. So I'll take that particular motion and eliminate under advisement, which is, well, it ties in with the state's number 6, but it's also defense number 1. Just going through the remainder of the state's motions in limine. Number 7 is really advisory. I understand that. We've already talked about number 8. The parties will meet and confer once the states narrow down their witness list. I'll grant 9, 10, 11, 12, 13, 14, 15, 16. I think we need to have a discussion on number 17 unless there is no objection to that. That was prohibiting the introduction of evidence about any alleged general drug or alcohol use by victim PPP.
We don't have any objection.
All right, then I'll grant that. Same thing with number 18. Do you have any objection to that?
No.
All right, I'll grant 18. Number 19 is appropriate. I'll grant that. 20, 21, I don't need to address. The state indicated it's not applicable in this case. 22, I'll grant. 23, I'll grant. Of course, that is subject to the rule of completeness as needed. 24, grant. 25, grant. 26, grant. 27 I see is also advisory unless there was anything specific the state was referring to in number 27. It seems a bit premature.
Yes, agreed.
And then 28 I'll grant. We still need to address number 1. There was no objection to number 2 in the supplemental or state second motion and eliminate, so I'll grant that. I didn't state it specifically, Teresa. I'm not ruling on number 2, but 1, 3, 4, 5. Sorry, 2 I granted. I wasn't, 1, 2, 3, 4, 5 were granted, 6 I'm deferring. And 7 was advisory. Okay. Before we get to the specific ones we need, well, let's just go through that. The state is seeking in number 1 in its supplemental an order prohibiting the introduction of any evidence or expert during the guilt phase of the trial as it relates to the defendant's use of marijuana on November 21 of 2021. I'll hear the state on that, and then I'll turn to the defense for their objection.
Well, really, my comments are much more than already stated, Your Honor. They have specifically asked this court to dismiss the counts related to his marijuana use. It has no relevance whatsoever to the charges that he's facing. It's confusing to the jury. It doesn't assist them in deciding any fact or element for the counts that remain. So we think it should be excluded.
It's not intoxication is not a defense, but that doesn't mean it's not relevant to a defense. I think all of these things, all of the circumstances that were going on that day, it would be just as relevant as if there was, if there was testimony that Mr. Brooks hadn't slept for 3 days. All of these things are important for a jury to consider when deciding the different mental states for the first-degree intentional homicide and the recklessness element for the bulk of the charges. It's no longer an affirmative defense. But that's all that changed. It doesn't mean that it's not relevant information in terms of his circumstances on his day. And that's the reason we'd be objecting to that motion to eliminate.
Any rebuttal?
Yes, Your Honor. At the outset, the defense had indicated on a preliminary basis, they may have an expert to discuss toxicology and or the effects of the marijuana on the person of Mr. Brooks. So it's very confusing to this jury because they've since told us that they do not intend to pursue that type of expert witness. So I don't know exactly what it is they're asking to tell the jury. If they want to just tell the jury that he used marijuana, well, first of all, let me say this. Mr. Brooks made inconsistent statements about that. On some occasions, he said he used it. On some occasions, he said he didn't. He told the detectives in the interview you watched that he wasn't under the influence of anything. So the record is pretty confusing that way. Are they going to just try and say he used it without explaining that further? Are they going to try and introduce the crime lab results without explanation as to what the number means? I don't know exactly what they intend to do with it, but I think it's very misleading and very confusing to the jury to even entertain this type of evidence. His use or lack of use of marijuana is not an issue. It cannot negate his state of mind.
If I were to grant this, well, let me ask it this way. Because it comes up in the interview, at least the one that I watched, I don't know what your intent is, but let's just say your intent is to show all of that. Okay, would you then be seeking to excise those portions out that deal with when he talks about this?
Yes. And the ring video, I don't know if you saw that part of the ring video, but when they took him into custody, there was some marijuana on the porch where he was standing. We would not introduce that evidence in our case in chief either. It has no relevance, Your Honor.
Well, what specifically is the defense seeking to have admitted or by way of evidence regarding his use of marijuana on that day?
I don't have the exact way that would be presented, but I'm seeking to not have that be prohibited. There is the crime lab result that we were on notice of. There's a reference by one officer in terms of, I don't know if they had smelled or believed that he had, their observations of Mr. Brooks. There's the comments, of course, depending on how it gets introduced in the statement. There's the ring video. It's all of the circumstances surrounding as close to that event as possible. Mr. Brooks's circumstances and what was going on with him at that day that we are seeking to have the ability to introduce through questioning of witnesses. There is an unpublished but authored opinion relatively recently that is somewhat helpful on this. I mean, it's for persuasive value only, and it was finding that it was not error when the court reminded the jury that it had heard evidence about defendant's voluntary intoxication, that it may be relevant evidence. And I can provide the citation to the court for that. It's State versus Ozodi, O-Z-O-D-I. The Westlaw site, which I think is going to be needed because it's authored but unpublished, is 2020 WL 7380279. That was 7380279. And the argument in that case was really just because this has been removed as an affirmative defense doesn't mean it's not relevant to the element of intent in terms of understanding really just in considering the impact that intoxication may have had upon somebody. In that case, the jury was instructed that it was not an affirmative defense, but then I think it was that it could be considered as relevant evidence.
It is true in this case that the court dismissed counts 78 through 83, and those were the counts related to the use of a controlled substance and then operating a vehicle that resulted in the death of another. There's very limited, if any, relevance to a jury hearing about, at least how it's been presented to me today, the use of marijuana on November 21 of 2021, unless of course Mr. Brooks testifies, and then it may go to his credibility, just like the use of alcohol, and whether someone is under the influence would go to their credibility, their ability to recall events, etc. Without really having more information from the defense, other than they are seeking to have this information not excluded on a more general basis, not really knowing whether it's toxicology reports that they're seeking or just simply his own statements that he told police. I frankly don't have much of an objection if the video of his interview is played in full and that part is included, if that's what the defense wants. Because a jury is told when the instructions related to hearing a recording and statements attributed to a party that they still need to determine whether those statements were made and whether to believe them and things of that nature. So credibility is still at issue for those statements, as self-serving as they may be at that point. So I think that part of the video I would allow in without it being excised out, but that's the extent at this point, unless I'm given a different reason and I'm persuaded otherwise. But clearly the toxicology reports, without being told whether an expert would be called and why it would be relevant to the charges of intentional homicide, first degree reckless endangering safety, what we sometimes refer to as hit and run, and the battery and the bail jumping, otherwise don't see relevance unless and until Mr. Brooks testifies, and then I think that would be fair game, his use that day. So I'll grant the motion brought by the state with the exception that those portions of the interview where he discusses his use of marijuana are admissible.
Your Honor, if I have a more specific offer of proof, can I submit that with additional argument then?
You may. All right, let's turn next to the defense motions in limine. Number one deals with exclusion of witnesses. I'm taking that under advisement to hear from the parties more fully on that. I'll remind me at the end of the hearing, they'll need to give the parties some deadlines so that the state files whatever they're going to file, but then the defense has an opportunity to file something in writing so that I can then decide it before we take testimony. Has the state otherwise reviewed the defense motions?
Yeah,
Are there any ones you specifically disagree or would ask that I deny?
Your Honor, I guess with regard to 2B, that indicates any reference by the state relating to their belief of Mr. Brooks' truthfulness or any deceptive behavior. Again, just so we're all clear, certainly the defendant gave inconsistent answers. We will be commenting on those in closing arguments, and I'm assuming there may be questioning. It's not our belief, but it's the facts of the case. So I just want to be clear that there's a distinction there.
I would agree with that distinction, and certainly closing arguments are fair game, but otherwise we'll grant that.
Thank you. With regard to number 4, that the defendant is referred to at all times by his name, Darrell Brooks, instead of being referred to as the defendant to avoid undue prejudice. Again, the title of this case is State of Wisconsin Plaintiff versus Darrell Brooks Defendant. We're not calling him Darrell Brooks the convict. We're calling him the defendant. He is the one who's charged in this case. I think that's the term that is used in TV shows. I don't see how that unduly prejudices him in any way. And I think the same thing goes for number 5, we would object to. It says that the alleged victims are referred to at all times by their names instead of being referred to as a victim. There's no question, and I think we've brought this up before, these people are victims. And I think this was brought up in the arena of the jury questionnaires. Now, what they need to decide is if they're victims of Mr. Brooks, the defendant. So when we say that, someone is running down the road and doesn't know the name of the person, but said, I saw one victim who was down on the ground. I don't know how else you would characterize that person. It was someone that they may have even seen get hit, but they don't know the name. And the same thing with the defendant. If someone says in their testimony, maybe it's a police officer, maybe it's a citizen witness who has been able to ID the defendant, that refers to him as a defendant, I just don't see how that prejudices the defendant at all. And I think I probably even used that term during the motions to suppress the statements. Did you have contact with the defendant? Did you see him in the courtroom? And I will refer to him as the defendant because that's his title in this case. So we do object to number 4 and number 5 for those reasons.
Before you get to any other objections, let me address that. I'll turn to Attorney Perry for a response.
Well, these are, it's all incremental. There's not one thing you could say, if this isn't granted, then the trial won't be fair, but we are seeking to have at every step of the way to remove even incremental kind of unnecessary prejudices that get away from what the instructions are, which is this presumption of innocence, kind of placing him in that stage. These aren't hard fixes, right, in terms of instructing witnesses and the way that we ask questions and refer to people as people and Mr. Brooks as Mr. Brooks. And it's in this context of this trial that we're seeking to have people not be referred to constantly as victims, because it's this trial that they're alleged to be victims of Mr. Brooks. And so we're not having a casual conversation outside of this trial. It is in this trial where that's what he's accused of doing. And so that's the basis for our requests for number 4 and 5.
I've had a longstanding rule, really, when I do trials, that all individuals, including the defendant and the victims, be referred to with their proper salutation and their last name. I think that just gives respect to what we're doing in this courtroom. It's not something I have done that I'm singling out this trial to do. And I agree with Attorney Perry about it being incremental. And likewise, for me, it's not a hard and fast rule. What I would hope